I think he said 28 deals last month. Cash. Didn't care the price. They're going to scrape it. They go, we don't care if the homes are any good. We're just going to scrape and start over. We want the zip code. It was like, it's hard to compete with.
That is, yeah, that is a non-starter, really. Where do you go with that?
Yeah, I was just like, I can't beat you. He liked it. I spent 7-8 hours with him, walking the park, marking the lines. He's like, I like you. I'll give you a discount, but I can't give you a $500,000 discount.
My
Like, why
gosh.
I can't pay $3 million next month? And he said, okay.
Wow. That is.
It closed. I've been following it for 6 months. It finally closed.
That is a crazy, crazy time right now.
So what they're going to scrape the whole thing and bring in new homes? Or they just,
that's what they're saying. There's like 30 vacant homes. I'm hearing an echo on me.
I'm not sure who that was. Might have been Phil.
Blame me.
Yeah, I'm blaming you. Yeah, you were the only one other talking. Sorry, Phil.
Ferd, do you own any? How many parks do you own in Kansas?
I don't own any in Kansas. I almost bought one in Pittsburgh, but didn't work out. I'd like to buy in Kansas, but I haven't found anything. I haven't found anything I like that bad.
Yeah.
I live in Kansas City. I've got a couple in Kansas City Metro, so close, but went after a couple in KCK, Pittsburgh, Topeka. I looked at one in Wichita, but didn't buy it. But I like Kansas. It's just there's none around Kansas City hardly. There's another one in Lewisburg I made a run at, but it's there's
is that because there was there legislation or something just to keep parks out of the KCK side?
No, Kansas City, Kansas has several. There's mostly bought up by bigger players.
Okay.
Johnson County is the affluent side of the metropolitan area on the Kansas border, and there's only 2 in all of Johnson County, and there are hundreds of lots. I don't know. There's one it's like 600 some lots, and it's owned by RHP. There's another one owned by some other big family office. There's just not a lot over there. Period. You're down to Phillips is down south. I don't know, 40 minutes or something. It's kind of
we're slumming down south.
Ex-urban. Yes, it's not really suburban. It's past suburban. That's how Lewisburg was, and some of theirs is it's just hard to find stuff close to the metro on the west side.
Ferd, and before we get started, we'll give just people a few minutes to gather up. Just curious about Topeka. You said you own in Topeka?
No, I own a retail shopping center in Topeka, which I sold, but I looked at trailer parks, mobile home parks in Topeka as well. But there was some big group bought almost the whole portfolio, the whole city about a year ago. I got called on it for comps, and I don't know the name of the group. I knew the broker that sold it, but they bought 6 or 7 parks in Topeka, and then I have another client that owns 1 park in Topeka, and the lot rents have gone from like 220 to 380 because the guy's cornered the market basically.
I think I talked to your Topeka person the other day because I was talking to someone who has 1 park there.
Okay.
I think.
Yeah, Topeka. I like the city of Topeka. I worked there. I went to Topeka like 15 times in a year. Got tax incentives approved on a retail center, and got to know the mayor and the manager and all those people. So I liked the administration, but it's a tough town for affordable housing. They got a lot of areas that need affordable housing, but they got a lot of old abandoned buildings. It's like 2 cities in one. One is affluent, one is kind of a ghost town. So I wasn't that jazzed about. I wasn't jazzed about paying 7 cap prices in Topeka.
I'll get that. All right. Well, I think we're gonna get rolling here. I know some people are going to be joining, and also one of the maybe confusing things and fun facts, we meet weekly on Mondays for the weekly calls with the team at 7:30. So some people just have hard time adjusting to 7 o'clock because once a month we meet with the guests. So today, that's you, our special guest for the month, and and some people sometimes just have a hard time adjusting just from 7:30 to 7. But for those of you guys who came, welcome, and thank you for being on time. We're gonna get started, and we have an exciting guest with us today. Very happy to have him. Have a ton of questions to ask as well, and the MHP lawyer, Ferd Neiman. And I'm just gonna run through our agenda today. So we're gonna have obviously a conversation. Ferd is going to talk to us on deal structuring, partnership structuring, do's and don'ts, and maybe some tips, something that we should be considering, but most of the folks that he is working with are not, and he just wants to let us know what's out there, what's happening, what we should be aware of, and we will do Q&A at the end as usual, and feel free to drop your questions as we go in the chat, and we'll make sure to ask them at the end. And we will go for approximately until 8, and then we will do breakout rooms so we can network and meet new people. And and so we'll just take it from here and see where the conversation takes us. So hope that sounds good. We're gonna get going. And so Ferd is probably, I don't know, Ferd, I think it's very, very unique. Not just the MHP lawyer, but park owner, operator, actual operator, who has done, is also a financial analyst, entrepreneur, and he has been dealing with all sorts of real estate transactions, and he has been involved in mobile home park investments, turnaround, retail development, redevelopment, residential investments, and real estate law. So the firm is working with clients nationwide, and that is one of probably unique advantages of Ferd's company. And they cover all areas from deal closing to structuring to operations in real estate to partnership structuring to even syndication and securities law. So there is so much to unpack, and if you would like to maybe just talk to us a little bit more and maybe cover the areas of your bio that we may like to know more about.
Sure. Thanks, Katerina. Thanks for having me. Steve, others, thanks for having me. Good to be here. Yeah, Ferd Neiman, I live here in Kansas City. Been here, went to school at Rockhurst University. Got a degree in finance accounting, MBA. Got my law degree at UMKC. Practiced different real estate aspects, as she mentioned. I was a county appraiser here in Jackson County, worked in economic development. Before that, worked in government for 5 years. Went and worked at a boutique law firm that did tax incentives and retail, not retail, but all redevelopment development. So did a little bit of everything, soup to nuts on real estate. Been operating and owning mobile home parks since 2014. Practiced law in a variety of areas, as she mentioned. I've got my broker's license, CCIM as well, so done some of that stuff. But really focused on MHP. I've sold all my retail stuff, sold all my single family, got a couple straggler duplexes, but really just focused on MHP the last few years. I think it's the most superior asset class for a variety of reasons. I'm sure you guys all know them. You guys are in the space and what makes MHP different. And really right now and today, you want me to talk about entity structures. I figured it's a relatively small group. Maybe I'll keep it brief on the monologue and give us time for some questions, but really talk about partnerships, entity structure, some of the do's and don'ts, syndication, as you mentioned. It's one of the easiest or first questions a lot of times people ask me is like, what's entity structure should I have? And the obvious easy answer is you'd never own real estate in your own personal name. Frankly, I wouldn't even sign a contract in my personal name. So I have an LLC that all it does is tie up property. It's called third Ivy Properties, third floor properties, me and my dad. It owns no property. I'll tie up a contract, third floor properties and or signs, and I assign it to a new entity. That entity is going to always be an LLC. You could do S Corp, C Corps, limited partnerships. You never do it in your own name, especially if you want to later on bring on investors or syndicate, or if you want to do a 1031 exchange, that kind of complicates it. Why an LLC? It offers limited liability. It offers pass-through taxation to the individual members. If there's more than one member, they get issued a K-1 as the LLC files a partnership tax return. If you are the sole member and you and your spouse would be deemed a sole member for IRS purposes, it's a disregarded entity and the taxation flows upward. So an LLC is strong on protection, and it is good as far as tax pass-through. So the next question on entity setup is typically, should it be member managed or manager managed? And how do I ultimately structure my my partnership or my LLC? Let's say it's Katerina, Ferd, and Steve. Well, who gets what? And ultimately the answer to that is it depends, and it's negotiable. And the key to make it a simple entity is that we're all active partners. And that means Katerina could be part of, her role could be looking for deals, negotiating with sellers. My role could be underwriting the deals and putting in the capital. And Steve's role could be operating the deals from a property management or even an asset management, or maybe Steve and I both do asset management. And there's lots of other things that you can do, duties and roles that make it where we're all active partners. And the key reason you want to make it all active partners is then it's not a syndication. And I'll touch on that in a few moments. But if you're all active partners, then you all can get equity. You do not have to be sophisticated investors or accredited investors. Big words for the SEC. And you really just want to figure out your splits. The three of us could say it's 1/3 each. We could say, I'm the money guy, I'm putting in the money, I want half. We could say, oh, Steve's the money guy and he's also signing the debt. He gets 60%, we get 20/20. That is all negotiable. So how do you set it up? Organizationally, I think you come up with a term sheet, deals. Hey, what are we good at? You look at duties and roles, and then how much you're going to work. How active are you going to be? Like, does Katerina have a day job as an accountant? Well, she's not going to be able to be doing leasing, showing, property management, maintenance calls. Steve might be, physically capable of changing a water heater, right? So he can do some of those maintenance tasks. Ultimately, you come up with your duties. You come up with who's going to do what work, who's going to put in the cash, and you negotiate over what percentage interest you have. And then you get into the minutiae of your operating agreements. Your LLC really has three components. One is an EIN, which is free, you get it from the IRS. Two is an articles of organization that you get from the state Secretary of State page. And that costs anywhere from $25 to $1,000, depending on if you're in Missouri or California. And then the third component, which is the most important, is the operating agreement. The state doesn't ask for an operating agreement. This operating agreement is the piece you pay a lawyer for, so to speak. If you're a single member LLC, it's just Ferd LLC, I'm the only member. I don't even frankly need much of an operating agreement. You can just say Ferd's the boss. Ferd can do anything, right? If it's Ferd and Steve 50-50, well, what 50-50 by vote, I can't do anything by myself, and neither can he. So we're neither of us are the boss, but we're both the boss. So there's kind of a poison pill in there. Now that can become inconsistent with progress. You look at like Congress, for example, it's gridlocked by design. It's supposed to be inefficient so that decisions don't get made to seat of the pants. Well, a 50-50 LLC does that. It could lead to struggles and challenges, especially with things like exit and things like sale of interest. And it's an operating agreement will include provisions like, how do I sell my interest? Do I want to? What if I die? Do we have key man insurance on me? What if I die and Steve, my partner, does Steve want to be dealing with my wife? She doesn't know anything about mobile home parks. So typically an operating agreement would say something like, my wife inherits my rights as it pertains to distributions and profits, but not my voting rights. So that would give Steve voting control. But he can't just vote to give himself, with limitation, he can just vote to give himself a big salary. He can't just vote to distribute 99% of the money to him and one to me. There'll be limitations on that. And that would typically be spelled out in your operating agreement. And if it's just by yourself, like I said, you can just take the first operating agreement you find on the internet. It doesn't matter. Really, the only reason you need an operating agreement is when you open a bank account, the bank wants to see who's the authorized signatory. And then when you close on real estate, the title company wants to make sure that you got the right people signing the documents. So they can get the signature block right on all your mortgages, your assignment of rents, your closing documents, all those sort of things. Key provisions that you're going to want to review in an operating agreement, if you're a minority partner, are things like capital calls. If it's Ferd's 51 and Steve's 49, 49% of the ownership is 0% of the vote, frankly. And if Ferd votes that we're going to do $1 million capital call, Steve's got to come up with 490,000. If he doesn't, what happens to his interest? Do I get to put it in for him? Do I have to put it in for him? Do I get to squash his interest to 0? Do I get to go outside? Do I get to charge him penalties and interest? Is he now a defaulting member? Can he vote? Things like that. Other things you want to look at is who's got to sign on debt. Now, some of that stuff gets fleshed out by the lender. I used to be in these retail deals with a high net worth guy, and we had $10 or $15 million of retail notes at any one time. The bank would require me, I own 10% of the deal. They require me to sign on 15% of the debt. So 1.5 times my interest. The other guy owned 90% of the deal, but he had worth $100 million. They want him to sign on 100% of the debt. So the bank had 115% coverage. Realistically, if the deal ever went south, who's the bank going to call? They're going to call the rich guy. He's going to get a phone call. Hey, went south. You got a $30 million land loan. I need you to cough up $30 million. I'm going to disappear, right? No, he's not going to disappear. In the operating agreement, he's going to have a provision that says member 1 can go after other member 2 in the event member 1 covers all of a guarantor pledge to a lender. So those are the kind of provisions that as a minority member in an LLC, you really want to pay attention to. Capital calls, distributions. Do I have a right to distributions? Because with the same partner, we owned a Kohl's shopping center. Kohl's paid $1 million a year in rent. But because Kohl's had a short-term lease, the bank didn't let us take distributions or cash flow. So we had to use all the $1 million to pay down the mortgage. Well, the mortgage was like $550,000. Well, you want to know if you're going to have a right to distribution. So in that example, I got stuck with $100,000 income, but 0 distributions, which means I had to pay tax on $100,000 with no new cash from that project. So you have to plan. Do you have cash from other projects? What if you want to sell? Can I sell the Catarina? I don't know. The operating agreement covers that. It is the partnership agreement. So you need to make sure you read that and understand that. And then there's also things like who's the tax matters partner. Typically it's one person who is the person that gets to sign the tax documents and determine are we going to take depreciation, things like that. So again, high level, to be an LLC and not have to be a syndication, you need to have active participation from all members. And it doesn't mean that all members can do everything and have real authority. That would be a member managed LLC. More commonly, you probably see a manager managed LLC, and the members vote upon a manager, which could be another entity. We just closed on a property today. The manager is FFLA, or Ferd, Love, and Andy. This Ferd is the manager of said entity. So practically, I'm the manager of the project. I'm the one that gets to sign and have to sign the closing documents for the lender, for the title company. So then the LLC, the norm is typically taxed as a partnership. It can be taxed as a partnership or a corporation. Generally better to be taxed as a partnership. The exception to that would be, like I have one property management entity that I work for, pay myself a salary, and several other members of my team work for. If they're W-2 employees, 2017 Trump tax law put in some additional carve-outs where you can, depending on your situation, if you pay enough wages relative to net income, you can have an additional, I believe it's 20% deduction. So I converted my management entity from a partnership taxation structure to an S corp, which you're allowed to do once. It's called the change of accounting method, and I did it after the 2017 Trump tax law. And depending on my fact pattern in any given year, it's either going to have no negative impact or it's going to have a positive impact of additional deductions. So there's some rationale that the property management entity should be taxed as an S corp. Other than that, I don't advise it. Structurally, I always hold the land in one LLC. We just closed on this park in Independence. Independence MHP Land LLC. The homes, Independence MHP Homes LLC, have different functions. They may have different timelines, which could impact it. If the Homes LLC churns, it could be labeled as a dealer for IRS purposes, which would potentially neuter my passive income and turn it into active income, ordinary income, which is taxed pretty painfully. So the land LLC is my passive entity. My real estate permits here, my retailer license, my mobile home permits are here. If I have home rentals, which this park has some home rentals, I collect home rent here, I sign a home lease here, I send the lot rent over here to the land lessor. It makes the land lessor more profitable, cleaner, better for my refinancings, better for my disposition. And it's also legitimate. It also bifurcates the risk. Now on that deal, I happen to bring in, I have a third entity, my property management entity, which gets paid by these two. These two are considered subsidiaries because the sole member of them is the Investors LLC, because I have investors on that deal. So in that case, the Land LLC and Homes LLC are single member entities, which the IRS calls disregarded entities, which means that this land and home do not even have to file a tax return. All of their profit and loss flows upward to the Investors LLC. The Investors LLC files a partnership return. This is in Missouri, so it files a state Missouri return, files a Form 1040 to the IRS, and it sends out K-1s to the investors. There are 6 or 7 investors in that deal. They all get a K-1, they all get a pro rata membership. As we move into investors, what I have to do there, it's an LLC entity structure, but it requires something additional. And I talked about the operating agreement, which is really the controlling document within an LLC. The controlling document for a syndication, which is when you have investors, it's a syndication, right? Because my investors are passive. I was talking earlier about equity and active management. My investors, some of them will never see the property. Some of them will never see me probably. We don't know them, which I'm allowed to do, and I'm allowed to advertise if I only let in accredited investors. That's a 506C regulatory syndication. The 506B, as in buddies, I can let in buddies of mine if I have a materially significant pre-existing relationship and they're either A, accredited, or B, sophisticated. So for example, I have a friend named Steve who is a very sharp real estate attorney who got the highest score on the bar exam in the state, was #1 in law school, and he worked in real estate and financial law for 5 years. Even if Steve's net worth was less than $1 million, excluding his house, which is the first way to qualify as an accredited investor, or if Steve's net income, or Steve's wage is 200,000, or if you're 200,000 or up, 300,000 if you're married, for each of the last 2 years and the forthcoming third year, makes you an accredited investor, or even net worth, not including your personal residence. If Steve Johnson here was in that definition, he's automatically an accredited investor. But this other Steve, who is not in that definition of income, he may qualify, and I think, in my opinion, he does qualify as sophisticated. He can get in a 506B as in Bravo offering. You're allowed to let in up to 35 non-accredited but sophisticated investors in a 506 Bravo. The 506 Charlie, you cannot let in any of those guys, but you are now allowed to advertise, which allows you to find people on the internet, find people you don't know. In either one of those circumstances, in order to maintain limited liability as a promoter, because if you're the one promoting the deal, you're a promoter, you're a syndicator, you're a general partner. It's all the same thing. The other guy, the rich guys that send you private money, send you quiet money, those guys are limited partners. And they're limited so long as they don't get active, which is in their interest to not get active. Otherwise, if they'll go south, they may get in trouble. So that structure is called syndication, but a more formal term is you have to either A, be regulated by the SEC, or B, be exempt from regulation by the SEC. And in order to be exempt, you have to be what's called a private placement memorandum. It's a big legal document. We just did one the other day. I think it's the core private placement memorandum is about 110 pages. Then there's an operating agreement that flows with it. That's 70 pages. And then a bunch of exhibits, property management agreement, subscription agreements. You have to do an investor questionnaire. And you have to do if you're doing the 506 Charlie, you have to do third-party verification. So I'm getting emails the last couple of days from CPAs and financial advisors saying, hey, this guy Jeff, he's legit. I've seen his books. This guy Steve's legit. I've run his financial. He's got $1 million in checking, that kind of thing. This is an additional threshold. But by doing those things, I can be a general partner, a promoter, and be immune essentially from liability. If I let in even one person who's not fitting those definitions, I one bad apple ruins the whole bushel. I could be liable, which frankly wouldn't be a problem unless it went south. Nobody's probably going to complain. You know, on your team, the SEC could come kick tires, and you also have to make certain regulatory filings at the SEC. So most people that come to me say, "Hey, I want to do a partnership, but I don't want one of those syndications." I get it. They don't want to do the syndication because one is complicated, and two, the legal fees are a lot more expensive, right? So they don't. I get why they don't do it, and I sometimes burst through the bubble and say, "Well, you're taking on massive risk, and you can't just call." And there are even sophisticated players that have 25, 30 mobile home parks that are like, yeah, we just don't do the syndication. And I'm like, first time one goes south, you know, you might lose your house, even though you're in an LLC. And SEC comes in, you may get criminal charges or something. So how do you structure the partnership with GPLP? It's negotiable, right? An industry standard is more like the GP gets a portion of the equity for free, right? For putting the deal together, for founders' rights, for entrepreneurial skill, finding the deal, having the expertise, assembling the due diligence, maybe fronting costs, maybe signing on the note. These sort of things that a GP would typically do. It would be unusual for an LP to sign the note, for example. The LPs put in money, and what do they get back? They typically get a preferred return. So if I put $100,000 into a syndication as an LP, and there's an 8% pref, they call it, I would get $8,000 a year before the GP got a penny. If I didn't get my 8 pref, it would typically accrue. And it's depending on your PPM, it would accrue with interest or without interest. And then after that hurdle is hit of the 8 pref, the 8,000 to guys like me, the GP then gets his or her split. It's a waterfall. And the next step in the waterfall is, if it's a 30-70 GPLP, the next 100,000, 30 goes to GP, 70,000 goes to LPs. You can have additional hurdles. Say, hey, once I hit a 15% internal rate of return, for example, the split changes from 30-70 to 50-50. And again, that's negotiable. It becomes a little more complicated from a business plan, a little more complicated to pro forma, a little more complicated to monitor. But it's not rocket science. It's probably not Econ 101, but you can do these things. You just got to articulate them, and in order to get a win-win with the GP and the LP. That's typically how the structure works. Other GP fees you'll see in a partnership: asset management fees, acquisition fees, disposition fees, refinance fees. Sometimes you'll have a debt guarantor fee if you got somebody else. Like if I can't qualify for loans and I have a big enough net worth or experience, I can go find somebody else to sign the note, and that person typically must be compensated, right? Because there's risk. Even in a non-recourse loan situation, there are typically risks for what's called bad boy carve-outs, things like fraud, waste, stealing, things like that. But overall, whether it's a regular LLC, or you could do a limited partnership, but I typically recommend an LLC, or an LLC that's under the structure of the PPM, the private placement memorandum. It's typically negotiable. The key thing that makes you fall into syndication land is if one party is getting paid disproportionate to what their contribution is. So like if I'm the syndicator and I'm taking acquisition fees and property management fees and I get 30% without putting a penny in, and the rest of you guys are all putting in 100,000, you guys are doing nothing else, I'm being compensated to do the work. I'm a syndicator. I could call it I could pretend I'm not and call it an LLC. I could call it a banana. Doesn't matter. If it looks like a duck, quacks like a duck, it's a duck. And I see people come all the time and they say, no, I'm not a syndication. And I say, okay, well, I'm not doing your LLC in that regard. But that's kind of how it works. Typically an LP would not be subject to a capital call. Capital call, and I probably should define that, but basically the manager will say, hey, we need more capital. Here's that phone call. Send me your share of the check. In a regular LLC, it would be normal for, hey, I got $100,000 check. I need all 10 of you to send me 10 grand. If you don't, you're going to get squished and your interest can potentially go to zero. In a syndication, the silent money guys who are not active are going to be pissed if that happens, right? They're like, this happened through your fault. You're the only active guy. So typically PPM would not require they answer the capital call, but in the event of a capital call, they either get the chance to answer the call, or if they don't, they're going to get dinged and diluted. Because if I've got 10 people in for 10% apiece on the LP side, I make a $1 million call. If Katarina doesn't kick in her 100,000, I'm going to go to the other 9 of you guys and say, who wants to kick it in? If Phillips kicks it in, Phillips now got 200,000 in relative to Katerina's 1. Well, she went from 10% ownership, she'll get diluted to 5. He goes from 10 to 15. Everybody else is still at 10. That's one way to structure it. It could be in interest or penalties. It'll typically be you're deemed a default, so you lose your voting rights, you lose your rights to distribution. Those would go to Philip until he's caught up, and so on and so on. That's fairly typical. What's the pref? Is it supposed to be a 7 pref, an 8 pref, a 9, a 10? Again, negotiable. My first syndication was a really hairy deal, and I had never raised money, and I had like 35 days to raise $750,000. So I offered a 10 pref, in 35-65 splits. My deal we closed today was a 60 for the GP, a 40 for the LP, and I only paid an 8 pref. So I've gotten almost twice as much value as the GP, but it's easier to raise money in your second deal, your third deal, your fourth deal, your fifth deal with the same investors in the deal. So, and then another thing that I want to mention, if you're part of the GP, you don't have to be accredited or sophisticated. So that's the beauty of it. In an LP, you got to have accredited people or sophisticated under 506 Bravo. But if Katerina finds the deal and her and Steve are already partners and those two have an LLC, they go find the deal, they bring it to me. And let's say both these guys make $5,000 a year and have a net worth of $5,000. They're not going to qualify as accredited. If you don't otherwise qualify for sophisticated, then you'd not be able to be an LP, but you could be part of the GP because it's your deal. And you're basically raising money for your deal. You're not, you could, but if it was just Katerina's deal and Steve made 5,000 a year, had a 5,000 net worth, she can't let Steve in as an LP. But so what sometimes people do to get in the game is they find the deal and they assign the deal or wholesale deal for a fee. Sometimes they do is they try to keep their fee in the deal, but they got to be part of the GP, which means that typically if you're in a GP, if it's the three of us, all three of our pictures are going to be in the PPM. All three of us are going to have active management. All three of us are going to do numerous roles, and we're going to have some staying power in the final entity post closing. So that's me talking a lot at you guys, throwing a lot at you. Why don't we ask questions and go from there?
Yeah. No, that is actually, there's a really good points too. I did not realize also when I was first time my encounter with syndication that if you're GP, you don't have to be accredited. I was really nervous about that part, but that is the beauty of when you are finding the deal and putting the deal together. So that is excellent point. I just wanted to ask you also, Ferd, I early on, and I used to also think that depending on the size of the deal or number of parties, investors that are participating in a certain deal, that it may just kind of automatically almost disqualify you from being a joint venture. You kind of have to go syndication route. Are there, sort of gray areas, sort of just, I guess, maybe rule of thumb or just practical advice how to treat it, to distinguish it clearly?
I don't know that I don't think there's a rigid number that makes you have to be a syndication versus a joint venture or an LLC. I think the practical problem is if there's 100 of us, how many of us are we really all actively participating? I mean, somebody who's showing the houses, 1 or 2 of us. Who's putting together the financials? 1 or 2 of us. Who's doing the underwriting? 1 or 2 of us. Who's doing the risk management? 1 or 2 of us. Who's doing the legal? 1 or 2 of us. I mean, and there's probably some overlap there. So I think there's an issue with trying to pass the smell test on that, but I'm not aware of a firm guideline. And the other thing is, if you're already you already have this material relationship with one another. So I know Steve better than I know Katerina, right? So it's feasible and realistic that Steve and I are sitting around, having a beer, having a cup of coffee, say, hey, we should go pursue mobile home parks in Kansas City. Tell you what, I'm gonna go find them. You go find, you go practice law, save up some money. You can put in the money. We'll jointly underwrite it. We'll jointly supervise it. We'll jointly get bids. We'll jointly do the due diligence. Let's create an LLC together. And that's kind of organic. It's possible that I put in all the money and he still gets 50% of the money, 50% of the deal, because he's doing arguably then more than 50% of the work, but I'm active. So it doesn't have to be pari passu or pro rata on dollars and interest. But if we then decide to let Katerina in and she didn't do anything, but she's going to write a big check, that's a syndication, even by one other person. Mm-hmm. You and I don't know each other well. Is it feasible that you and I come up with a deal together? Perhaps, but it's probably got to be a deal that we don't have yet. It can't be, you already have it under contract. You call me, hey, let's do this together. Now, it's pretty gray. It would depend. Have you already marched down the field of your due diligence and now you're on the goal line and all you need is somebody to write the check? Or you just tie it up and you're on the 5-yard line, you got 95 yards to go and you say, hey, I just found this deal. Let's together push it down the field, doing all these underwriting, due diligence, bank discussions, etc. So there's an aspect of that as to where the relationship is in the timeline.
Yep. I'm sorry. So, whoever can you, if you could please mute yourself. Yep. Thank you.
Got him.
Got him. Thank you. Sorry. Okay. And Ferd, one thing what was also quite interesting, if someone is getting pref, it also not necessarily, the deal does not necessarily become a syndication. That was also kind of interesting fact. Could you just explain that a little bit more? So it still can be joint venture, but certain partners are minority partners, so to speak, and they're getting pref.
Yeah, I think that would probably be unusual. I'm trying to think if I even agree with that. What you may see more likely is certain partners making loans to the partnership and then getting distributions in a priority order. Mm-hmm. Kind of like junior debt or preferred equity. Mm-hmm. I'm not sure I would call that a preferred return because, for example, if it was my 100,000 example, if I get 8% on my 100,000 and you're the promoter, you got 30 and I get 70 of the next 100, that's pretty much a syndication structure. Could you put that in an LLC? I mean, probably could, but what are you doing? Am I active management? If I'm also active, then that might be okay. But if I'm not active and you're doing the work and I'm putting in the money and that's why you're paying me whatever you want to call it, interest of some sort on my money, that's starting to quack like a duck. That you're getting essentially paid. You may be getting a salary, but you're getting paid essentially. You're getting equity disproportionate to what you would otherwise get. If you put in 0 and I put in $1 million, you're probably not going to get 35%. But if you're doing a bunch of work, well, you might get 35%. And well, that means you're being paid, even if your compensation is only the 35. I would err on the side of caution. Mm-hmm. There's a lot of stuff, in the law where you can be aggressive. Like, I'm going to go home here in half an hour. I'm probably going to speed by 1 or 2 miles an hour. That's against the law. That's pretty low risk of getting caught, and it's pretty low risk of being penalized harshly. People have aggressive provisions in their lease. People have, a lot of things that are aggressive. The things that I would probably not be aggressive on are anything that impacts the SEC, mm-hmm. because they got a whole team of guys in suits that look for bad actors like that, because they consider you a bad actor because you're out there syndicating against the rules, raising money from little old ladies, and you're going to flush it at some point because if you're not doing it right, and then that's not, you're basically bad for society if you flush the money. So that's why there's the accredited investor threshold, which, by the way, that definition is from 1933. They probably should update it. But you think 200,000 a year was a lot of money in 1933? Yeah. Was a $1 million net worth? Yeah. So the original impetus for this concept was very wealthy people who could stomach the loss. That's the point. Is once you either have and I frankly don't agree with the definitions, because I could be the smartest lawyer in America, make $199,000 a year, and I got a net worth of $999,000, and I'm not accredited. You could be the dumbest surgeon in America, but you're a good surgeon. You got $300,000 student loan debt, negative net worth, but you got a $201,000 salary, and you're a big enough boy to get the deal, and I'm not. But they had to make some sort of metric, I guess. But you'd think there'd be some other tangible aptitude, and there is movement with the SEC that if you have your securities license. I used to have my 6 and 53 when I sold mutual funds and stuff in grad school, that they have some of those tests. I don't know which ones they are. I'm sure it's the 7. I think it's a 7 and 65, maybe 70. If you pass that test, you're de facto accredited, because you're an expert, de facto sophisticated at least, because you've proven financial competency in a related field.
Yeah.
But that's just like that. To my knowledge, that's just anticipated guideline at this point, or recommendations. That's not the new rule. It's being discussed, but it's not. I don't think it's real yet.
Okay.
Ferd, I've got a few questions here from the chats. I'm going to start going through with you. I guess one, since you're talking about SEC stuff, have you seen anyone come after by about syndications? Is the SEC actually coming after people? Is there a high risk of that?
Yeah, I don't know anybody.
Probability.
I don't know anybody personally, but yes, people get convicted of that all the time.
All the time. Okay, so is that common in the real estate industry, or is that different industries and sketchy folk?
I think it's any kind of it's not real estate specific. I mean, there's startups. I actually invested in a startup. Now that I think about it, I invested in a startup with a guy. He was like the vice president of Mars Candy Bars, and he came up with some other, Jimmy Dean eggs and sauce. He came up with like a competitor to Jimmy Dean for like these healthy breakfast sandwiches, and he made a bunch of violations, and he got indicted, and the company went to zero, and I lost 100% of my money on that. I mean, he was doing a lot more other bad stuff, which is what they got him for. But yeah, people get in trouble with this stuff, and it's actually criminal too. Okay.
And someone else here, you touched on it, and I think you went fast through it. If my partner and I JV on a deal, you and I, and then Katerina wants to throw her money in with no controlling, I'm assuming that means no input.
Management. Yeah, right.
No management. Explain again how that works real quick.
It's a syndication.
That is when we're for sure in syndication.
That's territory. A syndication because you and I have she's put in money to do not do work.
Okay.
She's not active. Now, what I see people try to do is they try to make it a colorful argument that she's active by saying, well, she puts in money, but she also visits the property once a year, writes up some inspection reports, she reviews our financials, she's part of the quarterly meetings and asks questions and does planning. And that gets closer to not a syndication, but I wouldn't want to hang my hat on that if the SEC called.
So really, because you and I were in business first and someone else jumped in at that point, it's syndication. If the three of us start at the same time, it's GP.
In that example, it's not necessarily the timeline. It's the duties. You and I could have, well, let me give you an example. My friend Logan. Dad and I were buying and renting rental houses by my alma mater. We got tapped as it pertains to agency loans, CMBS loans, because you only have 4 regular loans on your personal credit for single family. I wanted to buy a 9th house. So I could go get a commercial loan, but that wasn't attractive. I wanted to do a residential loan. So so we modify a company. We can let Logan in. He's now active though. And he signed a note, he did work, all this. And then the 9th house was on his credit. So we let him in the company, which actually was a different LLC, but he came in as active. If Katerina, in our previous example, comes in as just throwing in money, well, she's an LP. But if she comes in and we make an amendment and we sell a portion of our interest, that's fine. I mean, I own my law firm, 100% me. But if I got 2 or 3 or 4 attorneys that want to be partners and produce work, I may say, I'll sell you a portion of my law firm, or I'll give you a portion of my law firm. And they're going to be active participants in the law firm. If Katerina said, hey, I want to launch your law firm to get marketing nationwide, I'm going to put 100,000 in, and you can pay me an 8th breath. But she's not a lawyer. She's not really actively helping practice law. It's the same thing on this real estate syndication. Lawyers even have more restrictions. You have to be a lawyer, but it goes back down to the active participation.
Okay, and so
I'm oversimplifying that, but that's the core tenet, is that she's not just a passive investment.
Okay. And where's that threshold of active? Sounds like it's got to be more than you attend the meetings once a quarter.
That's going to be very fact specific, and it's going to be go look at the cases and go look at the people who are convicted. And it's kind of one of those things. I think I told you this the other day. If I'm hiring somebody and during the application they say, "Hey, do you guys drug test?" They already failed the job application, because the only people that ask you to drug test are people who can't pass a drug test. So if you've got to ask, is this going to get me in trouble? Go do it right.
Okay, fair enough.
Good rule of thumb.
That's a good rule of thumb. Yeah, yeah. Good way to put it down to make sense as we all screen people for our homes. Let's see. I had a question about what you put in place to protect an LLC when a capital call happens, and you hit on that. When an LLC, let's say just we're talking general partnership, when that's going to end, what kind of provisions? How do you prep for that eventual end?
Well, typically the operating agreement will have some provisions on dissolution. I mean, informally, you terminate it with the state, Secretary of State and Senate. You go pay a fee. You terminate the LLC. You file what's called a final return, a final tax return. Typically, there's a reconciliation or an accounting process. And I mean, whenever I sell a property, I terminate the LLC. It's one and done. I don't reuse it. I don't want to retake on liability, things like that. So I sold that mobile home park in Taylorville, I don't know, July 17th, so 5-6 months ago. So I terminated the LLC. We sold the property. We now owned it, no assets. There's no mobile homes. I have an LLC with no mobile home park. And now I have money in my checking account because we have the money from the net sales proceeds. So we distributed to the investors, to the members, just me and my dad, pro rata, 100% of the monies. We then closed the checking account. We had to do an accounting. We didn't get rid of 100% right away because we had 2 or 3 vendors that hadn't cashed an $82 check or something. So we call the vendors, hey, cash your check. We're closing the bank account, and we just distribute the money and close the checking account, close the LLC, file a final tax return with the CPA, and which they tell the IRS, and then you'd file a final partnership return, final K1s, and that's pretty much all she wrote. So I mean, there's different in the documents of the operating. There's more provisions of like, what if we terminate under bankruptcy, under foreclosure, or under one person dies, or what if Dad wants to sell his half? Can he sell it to Steve? Well, typically, in the membership units, which are basically the shares of stock of an LLC, have very limited transferability, especially practically if it's a minority share, because it's not, you know, if Dad owns 25% and I try to sell it 25% to you guys, you're not going to pay what it's worth because I got all the votes. He trusts that I'm not going to squeeze him. You guys don't know me that well. 75% of the ownership is 100% of the vote, with accepting limitations on manager power. So like on my syndication here in Kansas City that I had some real estate fund put up $500,000. They made sure to put in the provision that I couldn't give myself additional compensation that was agreed upon. And in that case, I could not add more debt to the property unless they had a majority vote, because if I could go put another loan on top and subordinate their preferred return, in theory, you know, and maybe do it. And maybe by doing that, getting a refinance, putting another loan on top, I've got all this cash, I can pay the pref and then do a waterfall, big distribution. I get a big check. But at the same time, I put their position in an inferior position. So those guys are a sophisticated outfit. They wanted to put a provision in the document, which I agreed to, because there's like 6 or 7 investors, but they were the big one. I agreed to put a limitation on my powers, and that was in the operating agreement, which is an addendum to the PPM.
And Ferd, I think most of us who are prospecting to purchase parks sooner or later come to find an opportunity when there is a partnership being sort of dissolved or are put in a position where they have to sell properties to, you know, to let one of the partners out. So, and they're going to have to sell and they're in all this bind. So what are the common mistakes made by, you know, that bring people to that, you know, to that point? And so we can avoid them, hopefully.
Yeah, I mean, I think that's tough. It comes down to, I mean, knowing what's in your documents if you're a minority owner, and then trying to negotiate. If you're a minority owner, you're a minority owner, right? It's hard to negotiate for the majority. It's trusting who you're in bed with, and that required good due diligence. I made that mistake before where I got in bed with the wrong guy and I didn't realize until I was pregnant, right? And it's a problem. And then you want a minority stake, and how do you get your money out? And if you're on the debt, we just closed the deal today, and I got 3 minority partners in it, and they either trust me or they're ignorant of how badly I could beat them, right? No, I mean, but frankly, you want to have your interests aligned. There's documents to protect them, but it's in my interest for the project to do well. It's in their interest for the project to do well. So let's continue to do so. If one of them wanted to exit, you can put in, it's called a buy-sell agreement. You can put, typically it's not in the base operating agreement. That's going to be a separate exhibit. And I mentioned with Logan, me and Dad, we had a buy-sell agreement. And frankly, because Logan and I were best friends, we could have, if I got sided with Dad, we could have voted and potentially done something against Dad's interest. Dad and I are father-son. We could have voted and potentially done something against Logan's interest. So, and or not just as a bad actor, but just different horizons. My dad may want to sell out and retire. Well, Logan and I may not want to sell it. So how do we figure that out? Well, you can have a couple different ways you can do it. You can say any partner can sell their interest at X value at any given point. And then once a year at the board meeting, you say, we're valuing the property. It's based on the last appraisal, or based on our balance sheet, or based on something else, or based on a vote. And then you do this once a year. It's based on a third-party appraisal, but that's kind of expensive in practice. So you can have that value in there, and you can have the right to do this. Another option is, back in these are more stock verbiage, but a put or a call. A put, I can force you to buy it. A call, I can force you to sell it. So what we did in that deal is, it's kind of like if you've got kids and 2 of them are fighting over the last piece of cake, you let one person cut the cake, and the other kid gets to pick their half first. So when you do it like that, what's the kid with the knife do? He cuts it as fair as possible. So that's kind of the concept here. So I can say to Katerina and Steve, look, I think my share is worth 100,000. Here you guys go. You guys can either buy it at 100,000. And if you don't buy it, I'm buying your share at 100,000. That's one way you can do it. Another way we can do it is we can say, at the last valuation we had annually, we deemed it at 100,000. I can force you guys to buy it now, but I'll get you set a put at such a discount. I can force you to buy it at 80, or I can force you to sell yours at 120. So you can have all those discussions, and you can put that in there. Typically, I don't put that in operating agreements, that level, but I've done it as an addendum. And then you also have sometimes key man insurance. Like I have key man insurance on me to the benefit of my investors, my bank, and my employees. So if I die, there's money that the show will go on. Sometimes lenders require that. Sometimes partners. My old business partner had, I don't even know, $25 million of insurance that the bank made him put up as additional collateral, because if he died, there was a risk that neither me nor anybody else in his family would have been capable of proceeding with the rest of the project plan. So that's typically not going to happen with a first project, second project, small lender who's unsophisticated. But at some point, that kind of stuff gets in there too.
Good to know.
Ferd, I've got a couple of, we're coming up on the end of our hour here, and I've got a couple of fast fire round questions for you. Not many here, so we'll go through them fast. Real quick, what states are you operating in as a lawyer in?
Probably, I don't know, 15 or something. I'd have to think about it. But probably more than that. Probably more than that, actually.
Okay.
20. I can operate anywhere. This is wherever the client says the project at. I can't do litigation in states where I'm not licensed, and I can't show up in court. I can't do evictions, which I don't do evictions anyway. But like I can do an operating agreement in Alaska. I've never been to Alaska, right? I can do a real estate contract in Alaska. I do state-specific leases on states I've never been in. I just did a state-specific lease for Ohio. I've never even been to Ohio, but I can read the code. I can modify a template lease, and I'm not practicing law in Ohio. I'm practicing law from my desk in Kansas City. So my bar license, my malpractice insurance allows me to do that.
Okay. And what is the minimum percentage a GP can own in a syndication with accredited investors?
I'm unaware of a minimum. I mean,
okay, negotiate however you feel comfortable.
1%. I mean,
okay,
fractional percent. I'm involved in this one startup, and I own I don't know, 0.25%, you know? So, and I'm not the GP, but like, it's just a division problem, how many shares you get.
Okay. And
Don't quote me on that. I don't know. I'm not in the weeds on SEC like that, but I'm unaware of a minimum.
okay. And then I have seen around a few times where people sell the LLC that owns the park in order to avoid getting retaxed. Is that something you employ? Do you encourage that? Is that what's your take on it?
It's a case by case basis. I just closed on a deal Friday as I was my client, and that's what we did. It's called an asset purchase agreement. There's pros and cons to it. It's a very complicated document. It's going to be more expensive from a legal side. It's not foolproof. Your lender's got to understand it. It neuters the seller's ability to do a 1031 exchange. It can mitigate and is designed to mitigate the property tax increase risk for the buyer. You need to have at a minimum a mutual indemnification provision whereby if the previous owner didn't rent to somebody because they were a white, black, or purple, that you don't get stuck with that violation and vice versa. You're buying whatever quality of title and quality of a phase one the previous guy had. So there are certainly risks with it. So you're definitely going to want to do a better job on your DD on the other items. But it happens. It used to happen in retail a lot. And I mean, not a lot, but with restaurants. Because restaurants sell at like Chick-fil-A will sell at a 4 cap. That might be $6 million. The construction cost was $2 million. Well, if I buy it for $6 million, it's going to, choke the tenant in a triple net lease. The tenant goes out of business. Now I got an empty building that's designed for Chick-fil-A. So even in a pass through like a triple net lease, these sort of things would go on.
Okay.
We used to do retail. We had a 50-acre plot. We'd do pad sites, and we would actually carve off the Chick-fil-A pad for that reason and do a Chick-fil-A LLC and then just sell the stock of Chick-fil-A LLC. I used to be county appraiser. So county appraiser, I know what county appraisers look for. That's designed to hide it from the county appraiser. But you got to look at your local law, see that's, you don't want to get in trouble either, but it can be a legitimate strategy.
Okay.
But I've only seen it happen. I mean, if it happens in 1% of the situations, I'd be surprised.
Okay. I think, Katerina, you had one more question regarding some Dodd-Frank news that's come out recently. We're wondering what you might know about this.
I was actually wanted to ask for first, do you do in your parks that you own lease to own options?
I don't think I have any lease to own. I mean, there's a mitigation. There's a number of strategies you can use, and I've got in the interest of time. Let's say go to listen to my podcast. I got about 3 or 4 episodes on these items. Mm-hmm. But you can do a lease to own. There's a different spectrum. You got the sale, which is the cash sale. Mm-hmm. You got the home rental. Then you got the sale through like 21st Mortgage, where you have some repurchase obligation. Then you got the installment sale, where you're basically a contract for deed, and you're carrying the paper. Mm-hmm. And then you got a rent credit. Actually, you got a lease option here, and then you got a rent credit. There's pros and cons to each. Dodd-Frank and SAFE Act would say that any seller financing or installment sale, which would be the lease to option, if the option fee is non-refundable, and which would be an installment sale, are, quote, illegal under Dodd-Frank and SAFE Act. So earlier we were talking about SEC. Do people get convicted? Yeah, they do. Under Dodd-Frank, do people get convicted? To my knowledge, no one's ever been charged. And to my knowledge, I know for a fact, Barney Frank said this is what intended to include mobile home parks, mobile homes. Secretary Carson, who's now toast, President Trump, and prior administrations said this shouldn't be prosecuted, and they're not. But it was never repealed. Dodd-Frank and SAFE Act included a ton of other stuff, like created the CFPB. There's risk that the Biden administration may change the position of enforcement on these matters. We shall see. If so, I'll change my view of the world on them. But I know of many operators that are using the contract for deed. And I've sold some of them my template, frankly, that I say, look, there's risk here, but the Dodd-Frank Act had guidelines that were never really promulgated into law that were designed to take care of and protect borrowers. And I put those guidelines like debt to income ratio, review their pay stubs, no interest-only loans, no balloons, no adjustable rate mortgages, things like that, that the buy here, pay here car dealerships do that were shady, which is that kind of stuff was happening on home sales as well. So that the Dodd-Frank say that were designed to prevent that kind of shady behavior. But frankly, the organizations never implemented the rules. Now, states are supposed to enforce it. I'm a member of like 15 state MHAs, and I'll always ask them the same question: like, "What are your thoughts on Dodd-Frank Safe Act?" And someone like, "I just bought a park in Nebraska," and they're just like, "Whatever." Yeah, everybody was worried about it back in 2005 or whatever. I don't know. We don't mess with. We don't care. And then you got states like Iowa. We just bought a park in Iowa a couple months ago. Iowa, a law firm who represented the MHA got legislation passed that basically said a lease to own was okay under Dodd-Frank if you use this state template. I'm not sure that I agree with that analysis. I think the lease to own, frankly, is inferior than a contract for deed. A rent credit has less risk, but also has less. I use rent credit all the time too. The downside is the buyers have no skin in the game. The ideal is to sell cash or to sell 21st mortgage or to home rent or rent credit. If you get into the lease to own, installment sale, and to some degree rent credit, it's a disguised mortgage. And if it's a disguised mortgage, you're in Dodd-Frank world.
So yeah, that is a definitely very hot topic, and for park owners, would you say, I know we have to wrap this up, and I mean, we can definitely talk about this for a while, and we're gonna drop in the chat for everyone contact and the website where they can everyone can listen to the podcast and more of this episodes on these topics as well. Just wanted to ask, Ferd, would you consider really that let's say operators who own larger communities there that are in a prime, so to speak, location, central locations, they should be maybe even more so aware of the Dodd-Frank and how they how they structure their lease to own or rent credit, and just maybe refrain from doing that altogether. Just do it.
I wouldn't say it would be metropolitan specific. I think, if you own one park and Steve owns 100, who's a bigger target? Are they going to make an example out of you or out of Steve? And that's why the bigger groups are more cautious on this. I've got a few clients that are big operators, and one of them in particular says, "No way, we're not doing an installment sale, or lease to own." I've got another one that's got 50 parks. They're like, "Yeah, we'll do it." It's really, it's my job to say, look, there's pros and cons. I'm not gonna write you a memo with my letterhead on it that says you're immune from the law if you do contract for deed. I'll articulate some of the things I just did about the risk and reward, and lots of people choose to go that route because it's easier, better for selling homes, perhaps, than just renting the home. Or more commitment than a rent credit. So it's a calculated risk. Just like, some people don't get a phase one, which I think is asinine personally. Some people don't get a survey. Sometimes it's okay not to get a survey, like in a plotted lot. And if there's a prior survey or in subdivision regs or something like that, there's lots of times where it's okay not to get a table A survey with all the details. It depends on like, if I go to a park and I can see that the lots are 200 feet by 200 feet, I don't really have a big worry of how close existing homes are relative to fire code, because the naked eye says it's obvious that they're not going to be 10 feet apart. So I don't need to pay for that table A item. I'm paying $1,000 to surveyor. So there are times that you can be aggressive, and there's really almost no risk or pain. If you've got 2 parks and you got 4 parks, and there are also, by the way, exemptions under contract for deed, under Dodd-Frank and Safe Act for limited circumstances. But if you're doing 50 of them, I think it's like 1 to 3 per state, and it depends what kind of entity structure you're in, if they even give you an exception. And if you own it, if you live there yourself, or it's your personal residence, you get another exception, perhaps. Again, I don't know all the state specifics on that on a state by state basis, but yeah, people do it all the time. people hire me to do it to make it less risky. People hire me to not let them do it. It's really client preference. And some clients do combination depending on the deal.
Mhm.
Like I don't like rent credit a lot, but I'll do rent credit on a home that I'm going to sell through 21st Mortgage for a couple months to get the down payment in.
Mhm.
And so in the 21st Mortgage acceptance is a legitimate process. I don't want to do rent credit for 10 years. So I would rather rent. I've got more park-owned home rentals than I do rent credits by far.
Mhm.
The rent credit to me is a vehicle to get the home sold by helping with the down payment. If I'm going to give away equity in the home, I mean, if I'm going to take 10 years to hold it, I'm not going to give away equity. I might as well own it and own it in 10 years and own it 100% in 10 years. That's my opinion, right? Again, that's not legal analysis,
Mhm.
just practical opinion.
Yeah. Well, Ferd, thank you very much. I mean, this is definitely, we can talk more, and that is, it's never ending. I mean, the range of your services is very wide, and your specialty being mobile home parks makes it very exciting for for our group. Potentially, every time you find a park or a deal, you start looking for a local attorney. This is and try and interview and figure out whether these people have ever dealt with mobile home parks. So hopefully for our group, this will be less of a question going forward, because Ferd is practicing pretty much nationwide, so and clearly knows all ins and outs, being a fellow park owner and investors alike. So Ferd, thank you very much for your time tonight, and thank you for sharing with our group all your knowledge. And we hope that folks took a note of your podcast and will be reaching out with questions, and definitely with the next upcoming deals.
Sounds
Thank you
good.
very
Thanks,
much.
everybody.
Thank you
Thanks,
very
Ferd.
much.
You
Thank
got it.
you.